Court is calling 2023 CR 9693, State of Texas versus Sergio Rodriguez Cerda. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor. Tom Nisbet on behalf of the defendant.
And are you Mr. Cerda?
See.
Yes.
All right. And we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English? So help you God.
Yes, Your Honor.
All right. You can lower your hand and state your name for the record.
Jacqueline Payan.
Mr. Cerda, everything that I'm going to go over with you are in English. Were those documents explained to you in Spanish?
See.
Yes.
And did you understand all the documents?
See.
Yes.
Counsel, have you received all the discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Cerda, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
See.
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Cerda, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of driving while intoxicated, third or more? Normally, that's a third-degree felony with a range of punishment anywhere from 2 to 10 years in prison and up to a $10,000 fine. In this case, if the state is able to prove up the repeat offender enhancement allegation, your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
See.
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Cerda, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, have you provided your client with information about his immigration status and the impact this plea will have on his immigration status?
Very much so, Judge. He has retained Roland Gutierrez's firm. He has an immigration lawyer there, Garcia. They have taken marital steps and positioned themselves for all the immigration consequences of the plea here today.
All right, Mr. Cerda, were you advised of the consequences of pleading no contest or guilty in the application of federal immigration law?
No.
No.
No contest.
No, I want you to listen to my question. Did you speak with an immigration attorney about your criminal case?
See.
Yes.
Did that immigration attorney discuss with you the impact this plea would have on your immigration status?
See.
Yes.
Did that conversation include the fact that you may be deported, denied naturalization, and not allowed to re-enter the United States?
Yes.
Do you understand the impact a plea in this case will have on your immigration status?
Yes.
And have you retained an immigration attorney to discuss with you the impact a plea in this case will have on your immigration status?
See.
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, you're to agree that you've been previously convicted of a felony, that punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. There are no applications. There's restitution to Robert Ortega. And if you do not show up for sentencing, your plea in this case will stand. If the court finds there is sufficient evidence to find you guilty, that will stand, and you will be subject to the full range of punishment, which is up to 20 years in the prison. Did you understand that to be the plea?
See.
Yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
Okay.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
guilty,
And to the enhancement paragraph, how do you plead? True or not true? How do you plead? True or not true to the enhancement paragraph?
true,
State any evidence to support the defendant's plea.
Your Honor, I offer State's Exhibit 1 and the attachments.
No objection.
Mr. Cerda, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon State's Exhibits 1 and attachments. So how much time are you all asking for?
Judge, we would ask for a month if possible. His family is here, his wife, all his children, extended family members, they come to every court setting. He is on a leg monitor the entire time he's been on bond. You have had no issues through the pretrial supervision services. We would ask for a month.
All right, Mr. Cerda, I'm calling you back for a sentence. You can either come back on February 12th or February 20th.
Say yes, I mean,
whichever's fine.
All right, we'll bring you back on February 12th. I'm going to give you the reset form and you'll need to be here at 9 a.m.
Yes, Judge.
All right, thank you. What is happening with this case?
Judge, we've reached an agreement with the police office to have an extension of her probation and amend the conditions.
All right, we'll see if I go along with that.
Yes, Judge.
All right, court is calling 2021 CR 1907, State of Texas versus Vanessa Rosano. Could I have parties announced for the record for the state, for the defense?
Monica Corolla?
Are you Miss Rosano? Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review this document
Yes, ma'am.
with your attorney? Did you understand it?
Yes, ma'am.
Right. Are you the same Vanessa Rosano who was placed on deferred adjudication in 2021 CR 1907 for the offense of theft of aluminum, bronze, copper, brass on March 1st, 2022 for a period of 2 years? Is that you? Oh, no problem. State?
I'm sorry, Judge. can you
That's
just have
okay,
another-
sure.
Which one is she going? This one. Violated condition number 2 on or about the 31st day of October 2022 in Bear County, Texas. The defendant Vanessa Rosano did then and there legally use a controlled substance, namely methamphetamine, in violation condition number 2.
How do you plead to that? True or not true?
And Your Honor, we'll waive the remaining violated conditions.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That is to deny the motion to adjudicate guilt, continue on her deferred, extend for 18 months, refer to felony drug court, also have GPS for 3 months, also weekly UAs, also parenting classes, also report 2 times a month, or in person or in Zoom, Your Honor. And that would be the agreement.
All right. Are you asking the court to follow that agreement?
I am, Your Honor.
Are you asking the court to follow that agreement? The fact that the state is asking so much of you and probation is asking so much of you, tells me you've done nothing. So I'm going to give you a choice because I don't know if you're going to be successful or not, but it appears that you have done nothing. And I'm looking at the docket sheet. And at the docket sheet, at first, this was supposed to be a pretrial diversion. And all you had to do was pay $547 for that to be done. And then we've had a motion that has been filed before and that has been withdrawn. And now we're back here. So here's your choice. I can extend you for 2 years. I'm not going to extend you for 18 months. I'll extend you for 2 years. Or either I'll send you to the state jail facility for 18 months. You'll complete it. You'll be done. You can do what you want to do with your life. Otherwise, I'm going to continue you and I'm going to follow these recommendations.
And my choices, what was the previous?
18 months in the state jail facility, or either you're going to be extended for 2 years. There'll be a referral to felony drug court. You're going to remain in custody till felony drug court accepts you. If felony drug court does not accept you, you're going to safety. So which would you prefer?
The second, the 2 years instead of the 18 months.
All right, the court will deny the motion, alter the amend conditions to include a 2-year extension, a referral to felony drug court. If not accepted, then safety. And this is all to be done in custody. Parenting classes, there's to be no unsupervised contact with minors. There is to be partial GPS for employment only. No employment as a home health care provider or with minors. The UA hotline till further notice, and field visits 1 time per month for 3 months. And then at probation's discretion. Probation, is there anything else you need? Is there anything else you need from the court to be successful?
Your Honor, if I could just provide the court with a little bit of information with regard to the parenting class
Yes.
that's been added as a condition. Ms. Rosano has a 2-year-old grandchild in the house where she lives. She has a 24-year-old son who suffered from significant mental health issues last year, which is how Ms. Rosano ended up caring for his child. He has gotten the mental health assistance that he needs. He's on medications and he's actually gainfully employed and living outside of Ms. Rosano's home. However, the grandchild still does reside with her and she is charged with taking care of him. This is something that she volunteered to do as a grandparent. It was her responsibility in her heart to do that. The unsupervised visitation that the court just imposed as a condition of that probation. In light of those circumstances, I was wondering if you'd reconsider the unsupervised visits that you impose. It has nothing to do with any dangerous conditions in her home that she has created. I do understand she has a positive or an admission to using methamphetamine in 2022. However, that was prior to her having a grandchild. So I don't know if the court would reconsider unsupervised.
Well, let me ask this. Has she been reporting? I know that's an allegation in the motion, but there was no plea of that. So has she been reporting?
Correct. That was, she has not been reporting, which is why we suggested a GPS for 90 days to get her back on.
Has she
track.
done any, since she hasn't been reporting, that means that she hasn't done any UAs. Am I right in assuming that?
I believe that would be a safe assumption.
All right. So I don't know if she's using meth or not, but I do know if you're using meth, you shouldn't be babysitting anybody's grandchild. All right. So that's where we are. There's to be no unsupervised contact. And I don't know if Child Protective Services are involved or not. They probably should be. If the option is your son has mental health issues, so he should not be alone with the 2-year-old. And then you're using meth. That's not a good combination for either parent for a child if your son is not on his medications.
My son, he's taking Zoloft. He's been taking Zoloft for almost half a year now.
All right. So then that's where we are.
Yes, Judge.
All right. Thank you.
Thank you, Your Honor.
All right. If you need anything, you feel as though probation is not addressing the issue, you can always come back to the court. Do you understand? All right. Thank you.